Today, I want to talk to you briefly about impeachment. I'm not going to get into the politics of the matter. I'm going to attempt to explain to you the law regarding impeachment. This is a matter that's of vital interest to our republic right now, and it's in the news every day and just about every hour of every day. So I think that you might benefit from a brief overview of what impeachment is and how it works. Impeachment is a proceeding that is provided for in the Constitution of the United States to remove a federal officer from his or her office. And the objective of the proceedings is not so much to punish the officer that's being removed, but to protect and rehabilitate the office that the person occupies so that it regains its dignity after the malfeasance or the misbehavior of the person holding the office at the time. Briefly, we will get into how impeachment starts, how it's conducted, and how it is completed and then terminated. The process itself, as I said a moment ago, is provided for in the Constitution. The Constitution provides that impeachment must start in the House of Representatives, which is sometimes called the lower chamber of the United States Congress. The House has to commence proceedings if they're going to impeach somebody, and typically what happens is there's an investigation that is conducted, and sometimes this investigation may begin outside of the House of Representatives. For example, it might begin in a committee of the Senate, or it might begin as under the appointment of a special counsel to investigate matters that are considered to be worthy of investigation with a view toward impeachment. If the matter is deemed to be worthy of impeachment by the investigating authority, which could be a committee of the House of Representatives or any of these other ones that I just mentioned, the House of Representatives has the sole power to determine whether or not an impeachment is going to take place. And the Constitution specifically says that the House has sole power to impeach in Article 1, Section 2, paragraph or clause 5 of the Constitution. If the House decides after its deliberations that impeachment should go on, then they will vote on articles of impeachment, and a simple majority vote in the House of Representatives is required for the impeachment to go forward. So if the House, after its information gathering period, determines by a simple majority vote that impeachment should proceed, the articles of impeachment are voted upon, passed if they get 51% of the vote, or more than 50% of the vote, we should say, a simple majority. Then the impeachment goes into effect, and the party is impeached. This is somewhat like an indictment in our criminal jurisdiction, where matters are presented to a grand jury. The grand jury votes whether or not a true bill of indictment should issue. And if they decide that a true bill should issue, then the person is indicted. But that does not mean that the person is guilty. It's simply that the investigating authority in that case, which is generally an attorney general or some other authority within the state or the federal government, decides that a person should be charged, and the indictment is simply a charging document. It's the same, essentially, with the articles of impeachment. They're simply the charging document. If the House of Representatives has a majority vote to impeach, the articles of impeachment are presented to the Senate, where the trial of the matter will take place. If it's the President of the United States who is being impeached, as opposed to, say, a federal judge or other civil officers of the United States, then the Chief Justice of the Supreme Court of the United States will preside at the proceedings in the Senate. The proceedings in the Senate, unlike the proceedings in the House, require a supermajority to convict. Since we have 100 senators in the United States Senate where the trial is taking place, that means that 67 of them have to be in favor of conviction in order to remove the person being tried by the Senate from office. Now, the way the Constitution reads actually here is that 2/3 of the members present must be in favor of conviction in the Senate. So it might not be actually 67 senators if you have a quorum in the Senate, but you don't have all 100 senators present and voting. If the Senate determines during its proceedings that conviction is appropriate and votes on conviction by a 2/3 majority, often called a supermajority, the Senate finds the person guilty. If the person is found guilty under the Constitution, that person shall be removed from office according to the wording of the Constitution. However, there is a further provision that the Senate can vote on, and that is that the person can be prohibited from holding office in the United States in the future. And this has happened from time to time, but that is not required in the Senate proceedings. They can do it, but they don't have to do it. For the President, Vice President, and all civil officers of the United States, impeachment must be based on an accusation of treason, bribery, or other high crimes and misdemeanors. That requirement has vexed many a jurist over the last 2 centuries. Not the requirement for treason, that's pretty well defined in the law. Not the requirement for bribery, that's well defined in the law. But this clause in there that says for other high crimes and misdemeanors, there has been a significant body of jurisprudence develop around the definition of high crimes and misdemeanors. And for example, whether the word high applies just to crimes or whether it means high crimes and high misdemeanors. I believe that the consensus in American legal thought nowadays is that the requirement that misdemeanors be high misdemeanors is simply not there. If you think about the word misdemeanor, it really means misconduct. And if it's conduct that affects the dignity of the office that's being held by the person being impeached, that should be sufficient. And as a matter of law, it's whatever the House of Representatives determines is applicable regarding high crimes and misdemeanors. They will define what's meant there. And the Supreme Court has clearly stated more than once that This definition belongs in the political realm, that is to say within the House of Representatives, and not in the courts. That's called an issue that's non-justiciable. In other words, the courts are not to make that decision. The political body is to make that decision. And that's basically the law of impeachment at the federal level. Most states also have their own laws providing for impeachment. But that's basically the law of impeachment in the federal law, and I find it quite interesting. We'll see what happens. I have no desire to comment on the politics of the situation, but it's something that interests just about everybody that looks at the news every day, and we'll see what happens here. Thank you.